In the justice system, the people are represented by three separate but equally important groups: the judge, the defendant, and the plaintiff. These are their stories.
I would like to welcome everyone to Law and Order Discovery Dispute Unit, Episode 5, titled Evidence, What Evidence? This is Lockhart Technical Incorporated versus Brian Gale and Rob Gregory. Give a few facts about this case. The plaintiff is Lockhart Technical Inc. They are a software development contracting company, and they were hired by an outside company to create data indexing and tracking software. Our two defendants, Brian Gale and Rob Gregory, are former employees of Lockhart who oversaw the development of this project, and they now work for a competitor. The plaintiff in this case, Lockhart, has accused the defendants of improperly stealing intellectual property related to key portions of the software code from the project that they previously managed. In early June of 2016, both of these defendants resigned from Lockhart within a day of each other. And within a week, they both went to work for the competitor for whom they now work. Lockhart launched an investigation related to whether or not Gale and Gregory had taken trade secrets or IP related to the software development to the competitor, and after the conclusion of the investigation, filed this present suit. The complaint contains allegations that the investigation determined that the last internal Lockhart technical communications via email between Gale and Gregory was on April 2nd of 2016. After an initial meet and confer, the parties, the defendants in this case, agreed to produce data from their mobile phones. And after making productions, their productions were limited. They did not include any emails and did not include any data after April 12th, 2016. Throughout the discovery process and towards the end of discovery, it was determined by testimony of the defendants that they had installed and used ephemeral messaging applications, or EMA, called Dust, that encrypts messages, and then depending on either the automatic settings or settings in which the user can enable, deletes messages after they are read or within 24 hours, whichever comes first. Before this court today, we have a few issues. Did the defendants have a duty not to use this EMA application? Did these defendants have an obligation to continue with prior communication methodologies that preserved data? And did the defendants commit spoliation of evidence deserving of sanctions? And if so, what sanctions are appropriate? And with that, I will open for discussion and argument from the plaintiff. Ms. Clark, I will hand it over to you.
Thank you, Your Honor. Suzanne Clark for the plaintiff, Lockhart Tech. We're looking at two main issues. Did the defendants have a duty, and did they violate that duty in bad faith or in a way that cannot be cured such that sanctions are warranted? So, Your Honor, looking at the duty to preserve, you ask, did defendants have a duty not to use the ephemeral messaging app, or EMA? Or stated differently, did the defendants have a duty to preserve, and did they breach that duty by using an EMA? When there is anticipation or ongoing litigation, there is an obligation to preserve and produce relevant, proportional, and not privileged evidence per the scope of discovery requirements of Rule 26B1. Also, under Zubalaki 4, when litigation is reasonably anticipated or ongoing, a party is obligated to suspend its routine document retention and destruction policy and promptly place a litigation hold. EMAs are like auto-delete for emails and data put in place in a corporation's record management policy. EMAs have a bona fide use for data management, convenience, etc., But just like when a litigation hold is put in place at a corporation and auto delete is suspended during anticipated and ongoing litigation, use of an EMA, or at least the auto delete functions of an EMA, should also be suspended because the duty to preserve has been triggered. Let's look at the timeline in our case. Before April 2016, defendants Gale and Gregory installed the DUST app, an EMA, on their devices. June of 2016, defendants resigned and plaintiff Lockhart Tech began an internal forensic investigation. August 2016, this lawsuit was filed and a meet and confer was held, and defendants Gale and Gregory agreed to preservation of data on their mobile devices. Subsequent to August 2016, plaintiff Lockhart served RFPs and defendants only produced evidence through April 12, 2016. Subsequent to document production, plaintiff Lockhart took Gale's depo, where he admitted he and Gregory installed the DUST app, which is EMA, on their devices in April. The trigger of the duty to preserve could be debated in this matter. It could be as early as the defendant's resignation in June, but no later than the filing of the lawsuit in August. Once the lawsuit was filed, the defendants were involved in ongoing litigation. Just like a corporation must suspend auto-delete, the defendants should have suspended the deletion of their written or recorded communications, whether that be a voicemail, email, text, or something typed in a messaging app. The EMA the defendants used had an option for delete upon receipt or delete after 24 hours. But that is not significant to the argument. By failing to stop the deletion of data through the DUST EMA, the defendants have failed in their obligation to preserve evidence. If there was no way to stop auto deletion, they should have stopped using the tool. Instead, they kept using it during the course of ongoing litigation and did not disclose this until Gale's depo. So next, what about use of prior or other communication methodologies that aren't EMA? Were the defendants obligated to use these? Defendants aren't obligated to use any particular communication methodology. They are simply obligated not to allow the destruction of communications, and if their choice of communication is an EMA tool that does not allow them to preserve, then they need to proactively stop using the app. If they need to text instead of talk, they are obligated to do that in an application, platform, or tool that preserves the written communication, because they are involved in ongoing litigation and their duty to preserve has been triggered. So, the spoliation question. Did defendants commit spoliation of evidence deserving of sanctions, and if so, what sanctions are appropriate? Under Rule 37E, a court may impose sanctions on a party for failing to preserve electronically stored information upon finding prejudice or upon finding the party acted with intent to deprive. Your Honor, if you find prejudice combined with an intent to deprive, you should sanction the defendants. So was the requesting party prejudiced? Yes. The facts of the case relate to the theft of intellectual property by sophisticated information technology professionals. These defendant IT professionals had skills to hide information that plaintiff needs to prove its case. The plaintiff, as requesting party, had no other recourse or source of this information. The plaintiff is prejudiced by the missing information that defendants have control over. So is there a way to cure the prejudice through other data sources? No. As I stated before, the defendants are the only ones with control over this. They proactively chose to use an EMA in order to prevent plaintiffs from discovering the information. There is no cure. Well, was there bad faith? The defendants agreed at the meet and confer to preserve mobile evidence. That would include texting. By choosing to text in an app that they had knowledge would automatically delete their information, they were acting with bad faith because they knew their duty and they chose to ignore that duty. Furthermore, by not letting the plaintiff know until Gale's deposition that they were communicating through EMA, they prevented plaintiff from seeking recourse until it was much too late. Therefore, the plaintiff should be awarded a default judgment, or in the very least, the jury should be given an adverse inference instruction, instructed about the destroyed ESI, and instructed that they should assume it would have been information favorable to the plaintiff's case. Thank you, Your Honor.
Thank you, Ms. Clark. Ms. Cook, we'll hear from you now.
Thank you, Your Honor. My name is Amanda Cook, and I represent the defendants Brian Gale and Rob Gregory. To the first question of whether the defendants have a duty to not use ephemeral messaging, there's no such duty that exists anywhere to not use ephemeral messaging. The duty to preserve, as plaintiff's counsel mentions, only arises when there is anticipation of litigation. And the duty to preserve here in this matter didn't arise until August 2016 when the suit was filed. The application was installed over 4 months before that, so how could there be an obligation to preserve data that was not in anticipation of litigation when it was installed? Federal Rules of Civil Procedure does say that if ESI that should have been preserved in anticipation is lost because a party failed to preserve it and it can't be restored, the court can order a number of sanctions. But this data was inadvertently destroyed before any litigation was anticipated way back in April. And there is no local, state, or federal rule that I could find that mandates that people can't use ephemeral messaging. A corporation like LT may, as part of its policies, mandate that employees do not use these kinds of applications to discuss business information. But LT did not institute such a policy. It's a failure of the plaintiffs to institute such a rule that caused the situation that we find ourselves in today. Further, LT could have blocked the installation of these kinds of applications on company phones or computers so as to not raise any issues like these. LT did not avail themselves of this option, so should not now be able to argue that there is a duty not to use ephemeral messaging when they themselves did not impose such a duty. There can be no intentional action to deprive or destroy because this application was installed long before the anticipation was even an idea. They installed this months before they left the company, and it does not rise to a level, installing an application and using it does not rise to a sanctionable level. Under Rule 26, LT is entitled to discovery of any non-privileged matter relevant to their case and proportional to the needs of the case. LT is not entitled to all the text messages and emails, just the ones that relate specifically to this matter. And the defendants have already indicated that they only use DUS to send messages amongst themselves and to their attorneys once the lawsuit was filed. The text messages that have been produced so far do not support any allegation that there is additional information that's relevant to the case, nor has LT alleged what information they believe might be contained in these messages that were automatically deleted by the application. The rules don't permit endless discovery without limitation. They explicitly spell out that the needs must be, that discovery must be proportional to the needs of the case. And I would argue that LT hasn't proffered any evidence that indicates there are responsive communications that would be contained in the application or that the destruction was in bad faith. Turning to the production of emails, LT, as the party that has access to their own company emails and conducted a forensic investigation, shouldn't be seeking production of emails from Gale and Gregory. They're the party that's best suited to pull their own emails and review for any responsive information rather than trying to place an undue burden on defendants to try and get those. They also they've conducted a very extreme, forensic investigation, and they have not offered any evidence at all that supports their trade theft secret claim. Put simply, there's a lack of evidence that supports their claim in spite of their own forensic investigation. Many employees at a lot of companies use ephemeral messaging applications for all kinds of reasons. And it's not unreasonable that two colleagues and friends who are well-versed in technology and the knowledge that emails can be hacked and messages can be hacked would take extra precautions to protect their personal communications with an encrypted messaging app. Further, they disclosed that if they were trying to hide that they were using this, they wouldn't have disclosed that they were using the application prior to their departure. Respectfully, the court would be hard-pressed to find that using an ephemeral messaging app before a suit was even filed is evidence of intentionally destroying ESI that would be helpful to LT. Lastly, the defendants didn't take any affirmative action to change a setting or update a setting so that it would automatically delete. It's just a function of the application. And so sort of turning to the second question of whether they had a duty to continue using previous communication methodologies, we would argue no. Why would the defendants be beholden to a duty that didn't exist when they started using it? As technologically savvy executives, it's not surprising that Gale and Gregory would use new and novel technologies to test their features, see how they work, see if it works better than what the company is currently using. And because they began using this software, one, before they left LT, and two, before a duty to preserve arose, they don't have any duty to start using email or phone or whatever previous methodologies may have been used. Once the litigation was filed, they also don't have a duty to switch to personal email or text to discuss personal and/or privileged information. The rules do not impose any duty to only use communication methods that the plaintiff wants them to use. And lastly, turning to the sanctions question, defendants respectfully argue that there can't be any. There can't be a finding of spoliation because the application was installed before the suit was even filed and before the defendants even left the company. And there can't be a finding of bad faith with intent to deprive as a result, which is required under the rules. The court, of course, has the authority to impose a sanction they think is sufficient if they find that they intentionally destroyed evidence in bad faith, but they also have to find that the party acted with the intent to deprive another party. And the evidence here just doesn't support that. So we would argue no sanctions and that the court requests that LT present what evidence, if they have any, of their contentions that they're making and let the jury decide. Thanks, Your Honor.
Thank you, Ms. Cook. There are a few interesting things in this case that weigh into my ruling here, and I do tend to believe that several of them are a question of fact. One interesting note is that the email communication between the defendants, even while employed at Lockhart, ceased in April prior to their departure, months prior to their departure from Lockhart. Their use of the dust application has possibly continued after their departure. However, as we sit here today, we do not have evidence that has continued. I do believe that that the parties are entitled to present evidence to show that related information to the claims in this case have been exchanged in other methods and via the EMA methodology. I do not believe that the actions of the party give rise to entering a default judgment at this time. If evidence is presented at trial that communications related to the claims made the basis of this lawsuit is presented, I am not opposed and could deem it appropriate at that time that a jury instruction be given related to the information that was exchanged between the defendants related to the claims in this case, and an adverse instruction at that. However, the underlying evidence will need to be presented first, and then we'll let the jury decide whether or not that evidence is compelling to make a finding of fact either way. So as of now, I'm not compelled to enter default judgment. I will reserve the decision on an adverse instruction until such time as the evidence has been presented at trial. I will also further order at this time that Ms. Clark, that you draft a non-argumentative proposed instruction to the jury that be presented to the court at least 14 days prior to the start of trial, so that we have time to evaluate it in the event that the underlying evidence is presented that warrants such an instruction be given to the jury. All right.
Thanks, Your Honor.
So with that, we will take a look at some of the cases where we found some of our fact patterns here. Let me go back to sharing my screen. All right. So while the facts in this case are obviously made up in the opinions expressed here, were for the purposes of addressing an issue that we're finding more and more common and anticipate will be more and more common. We did base it on a few cases that have been recently decided. The facts in this case are somewhat similar to a case from the Western District of Arkansas. It's Herzig versus the Arkansas Foundation for Medical Care. In that case, there were two individual plaintiffs who were IT professionals who were ultimately responsible for a development project that ended up having some fatal flaws that released sensitive information or had holes in the development of the code that allowed for the release of sensitive medical information. They were ultimately terminated from their position and then filed a age discrimination suit against Arkansas Medical Foundation. They did at some point in discovery, towards the end of discovery, acknowledged that they had used an EMA for communication, which they said was personal in nature and only related to times when they were meeting with their attorney and or personal communication. The court did not end up addressing directly the use of the EMA application because they dismissed the underlying age discrimination case based on the fact that that the people who were hired to replace the plaintiffs, one of them was actually significantly older than one of the plaintiffs, and a few other procedural issues. So summary judgment was actually granted in that case on behalf of AMFC. However, there was some discussion about the use of the ephemeral messaging app there. Another case that was fairly complicated and had a good many issues. One which was related to the use of EMAs by both parties was Waymo versus Uber Tech out of California. That case, both sides had some issues. Uber actually had several issues related to production of documents. They also acquired a company during the process of this litigation or in the anticipation time period of this litigation. The court ordered that both sides could present evidence as to the use of the EMAs and let the jury decide whether or not there was evidence that should have been saved or preserved that was lost. But ultimately, there were a number of other issues that were also addressed, and the court did not grant a default judgment. And similar to the ruling in our fictitious case here, reserved the option for potential adverse instruction until after the presentation of evidence in the case, and that case ultimately ended up settling. So those are the two of several cases that have been going on fairly recently. There are more out there that are popping up on a fairly regular basis. So I anticipate that there will be more of these with the flood of these type of applications into the market. Another distinction with the Herzig case versus our case is the EMA that they chose did require some change in settings. It was noted by the court that both Herzig and Martin, due to their background and their roles as IT professionals, were tech savvy, and their use of and their manual change of the default settings made them more susceptible to some type of claim of spoliation because they had to intentionally and manually change the settings. With our fact pattern, the EMA that we referenced is called DUST. Its default setting is to automatically delete within 24 hours whether a message is read or not, and the only option to change those settings is to delete upon reading of a message. So the message is gone after 24 hours, regardless of whether or not it is ever actually read. So the slight difference in the tech savviness of the parties in that case, or the importance of their tech savviness versus our fictitious case here. And with that recap and discussion of the decisions, we will we'll take a few minutes and take any questions or discussion that anyone has.
Suzanne, you're on mute, I think.
Can you hear me? Okay.
Yes.
I had to press *6. All right. So I don't want to step on anybody's questions if we have questions from the audience, but just the discussion idea is, are these ephemeral messaging apps like text messages, or are they like a phone call, right? So once you're in litigation, are you required to start recording any phone call where you're discussing the litigation? No. And that's always been, I think, that's traditionally the way people get around this, is that they need to talk about the litigation, or they want to talk about the litigation, so they just pick up the phone and call. Now, are we going to say these ephemeral messaging apps are like a phone call because we're so used to texting, or are we going to say they're like text messages? Because those two are clear, I think. You know, you don't have to proactively record a phone call, and you cannot delete text messages. So what are we looking at here? You know, I think it also goes to, what do you advise your client to do, knowing that this is going to be coming up in litigation, and we don't have much case law yet, and it's probably wise to tell them it looks bad. It looks like you're hiding something, right? So maybe you shouldn't use it. Because I think that's a big issue here, is that it just looks like you're trying to get around your preservation duties.
And I think that it's not necessarily an ephemeral messaging app, but if you think about Zoom, and whether you record Zoom or Teams or any of those, with the explosion we've been seeing with using those tools and EMAs as well, I think that this is going to become a huge question of how do you advise your clients? What do you tell them to do? What are the duties? Do you record? Do you not record? Is the appearance of impropriety enough to make it so that you shouldn't use it? But is there that affirmative duty to not use? And I don't think that the courts have really said one way or the other. They kind of are just like, this feels like a lot. I'm going to go decide it on other grounds, you know? Like, I'm going to go over here and decide it over here. Like,
yeah, it really hasn't been from the background research that I've done preparing for this. There has been very little as far as a direct answer from the courts to this point. It's either I can decide this on other grounds, I feel compelled to mention it because it at least has this appearance, or I don't want to decide, I'm going to let the jury decide, because you know there's at least some question of fact, because one side is saying this had to have contained relevant data, and the other side is saying, no, we're just buddies, and we were talking about buddy stuff. We would never use this to talk about work things. So I think that for now, we don't know what the courts are going to do, and I tend to agree that it certainly at least gives some appearance of trying to hide something even if you're not. So,
and maybe that's all the jury needs to know is you were using the app. FYI, jury who doesn't know about about this is like they were making a bunch of phone calls and avoiding putting things in writing.
And I wonder if a good thing to think about is how you advise your clients with the use of their IT policies and ephemeral messaging. If you say you cannot use this while you are using a company computer or phone, and then they use it, then that inference of impropriety gets much higher. And I know I've gone to heard people speak about this where they're like they go give presentations on ephemeral messaging, and the CEO is like, we don't use that in the entire engineering department. It's like, we've been using it for 3 years for these projects, and like there's just that lack of sort of connection between the different levels. So I think that's sort of a comprehensive, social media / application policy is probably always a good thing to think about.
I agree.
All right. Well, I would like to thank everyone for joining us today. I would also like to thank our panelist, Suzanne Clark. Suzanne has had a career as a litigator. She now focuses her attention on e-discovery. She is a speaker and panelist in e-discovery education and is a consultant and manager and veteran of document review projects, large and small, various sizes, and also assists and concentrates on the plaintiff side of e-discovery, assisting counsel with evidence management in the mass tort world, all the way down to just single event cases for personal injury firms. Amanda Cook works here at Acorn with me. She's a senior project advisor. She's spent her career working in all stages of EDRM. She's an advocate for the use of e-discovery to reduce costs and increase efficiency, and she has a consultative and customized approach to helping clients achieve success and be cost effective in doing so. And my name is Jeff Hudson. I'm the Director of Professional Services here at Acorn. I have a variety of experience from being a litigator to e-discovery project manager to a technology leadership roles. I've worked in pretty much every area of the e-discovery lifecycle that you could have had a role in, and I like solving complex problems and trying to find some simple solutions that make our clients successful. So if you guys have any questions going forward, please feel free to reach out to us, and we'll be happy to get back to you and answer those. If you would like some links to the cases that we cited, we can also send those so that you can read them on your own as well. So we do have a question about how do you block installation of the applications on computers and phones? That is a bit of an IT question. However, I would start with a policy that prohibits certain types of installation or certain types of application installations. And then there are also some setting options that can be applied, particularly with mobile devices, that can limit the type of applications that can be installed, particularly on company devices. There are also specific applications that are designed for businesses and companies that set limitations and also allow you to maintain some control and some tracking capabilities over how business-owned mobile phones are used. And in the event that you have a bring your device to work situation where employees are allowed to provide their own devices, then you definitely need to have the policy in place there as to what the company has rights to access, and what the employee what their expectations should be as to what is private, which can range from practically nothing to some predefined scope, but there needs to be a clear expectation defined as to what the employee should expect is their data, if any, versus the company data. Because in the event that that employer is subject to some type of investigation or litigation, it is very likely that a collection of an employee's mobile device will be subject to the discovery process. And if you do not have a properly defined policy in place, or the proper tools in place to limit the scope of what can be utilized on a device in the event that the employer owns the device, it starts with a broad collection of the entirety of the device and can then be whittled down from there. However, all of that data will be out there in the collected data universe. All right. With that, again, I thank everyone for their time. And if you do have any additional questions or follow-up questions, feel free to reach out either to me or Amanda or both of us. And we'll be happy to provide an answer or track down the answer in the event that we don't know it right off the top. So thanks again, and we hope to see you next time.